Welcome to Financial and Estate Literacy. This is It's Your Estate, fall of 2023. And just as a way of introduction, let me walk through a couple of things here with you. In the material that you got on your notice of here's here's the link to the seminar. There was also a link that would take you to this kind of a page. It will show you, and I'll bring up the website in a moment. It will show you where you can go through and find out. This is a booklet workbook that I did a while back. It's available under this section right here, under the workbook articles. And also in that same area is Leave Me Alone in a Dark Room for a while, and I'll probably create something. So I created 3 booklets on basically estate planning and charitable giving and financial planning. They don't specifically week to week tie into what we talk about here, but I thought they might be helpful. They're more of a conversation. And in a moment, I'll show you exactly where to find those. Let me just show this. So the schedule we have is this week, we're doing an overview and estate law changes. Next week, we'll do healthcare and power of attorney, then wills and trusts, retirement planning, since our 401ks, IRAs are a big part of everybody's, seemingly, of people's wealth other than their house. We're off for 1 week for a variety of reasons. Following week, I will actually be doing the charitable opportunities session on the 27th. And Pete and Trevor will be doing estate administration at the end of that one. Where am I going down here? Let me share this instead, because Pete certainly correctly wants to have this show. This is the website. If you go into that website that you clicked on, it'll say workshops. You can come down here to either money or estate. They're both available to you. If you want to speed read, you can watch the past sessions and watch all of them whenever you want. These are also being recorded. So under It's Your Estate, this is the first week. And here are all the topics that we're going to be talking about. The handout material that I just talked about, the workbook is here, and the booklets that I did are here. Also, there's an Ask First form, which Pete will be discussing in a minute. When Kaylee does her presentations, there's the material that she's going to be presenting, and her Ask First form. So all of that is there, and it's updated every week. If we browse down just where Pete wants me to go, because he wants me every time to do it. What are these, Pete?
Here's some articles that might be of interest to you. Tax facts that make your head spin. Should you tell your kids how much they'll inherit? There's no right answer. But here for 2023, some of the changes in the area, the state of estate planning practice. Why wealthy women lag behind male peers in estate planning, 8 planning considerations. Talked a little bit about the step up in basis that we're going to talk about in a little bit, and the money talk with your parents when you may want to have it. Each week we'll have different articles. They're available to you to read on your own time, and you can always download the booklets or the outline. So let's go through. Kaylee, why don't you come on board?
And what I'm going to do is if you put in questions at Q&A, I will monitor those over the time. And if there are issues that I can answer, I'll answer them. If not, I will interrupt, because I always interrupt, and ask questions as we go along. So I'm going to disappear, but I will be in the background somewhere. Have fun.
All right. Kaylee, it's you and I.
Hi.
Why don't we bring up your Ask First form? And just to let everybody know while you're doing that, for every presenter that we're going to be doing for the next 5 weeks, we start off each session with the Ask First form. And it's kind of gives you an idea as to who you're talking to. All of our presenters are excellent. They're also experts in their area of practice, and I wouldn't have them on unless they were. And but these are kinds of the things that you need to know. Kaylee, where'd you get your master's or other advanced degree from?
So I got my I got my JD from Chapman University. So I went to the law school there.
Okay.
Yeah.
And after law school, you went right into the estate planning area?
I did. Yes.
And so your focus today is totally in the estate planning?
Yes, exactly. And so that was about 5 years ago. I started mentoring with I started a mentorship with another estate planning attorney, worked with him for 3.5 years. And then I branched off and started my own practice in January of 22, and
Okay.
exclusively estate planning and litigation, those types of matters.
Yeah. It, you're fairly new in the sense
Mhm.
that, do you think that you could handle more than one legal area of law to practice in?
What do you mean in terms of like
In other words, many
personal injury and
attorneys
estate
have
planning?
a kind of a menu,
Yeah.
family law, corporate, uh, and I find that very difficult because how can you be an expert in all those areas?
I find it a little bit disturbing as well, because I feel like in order to do something well, you have to be saturated in it, and you have to do it every day, and you have to devote your time and energy and life to it. And I feel that when I see that, I log into those other attorneys' websites and they have like corporate and business and estate planning and family. It's really hard. Each one of those areas has very niche rules. They have procedural rules and all kinds of other things. And you come to know what would be advantageous to somebody, in that field. So like what might work for what you think would work for a family law client, somebody with a lot of experience might not feel the same way.
Yeah.
And so I tend to think that you should see somebody who devotes their life and their practice to estate planning, because that's going to be where you will find it will be the most rewarding, in
Yeah.
terms of knowing that you're in good hands.
Yeah, I agree with you 100%. Stay away from somebody who practices in 5 different areas if you're going to do an estate plan, because usually that particular attorney will get something wrong.
Yep.
Relevant licenses. You are licensed with the Bar Association. And
Yes.
why is that important? Can somebody look you up and see whether or not you have any disciplinary issues?
Yeah. So on the State Bar website, State Bar of California, there's an attorney search option, and you can just type in an attorney's name, and you can see, a few things about them, contact information. You could see where they went to law school. You can also see if they've been disciplined, or if, disciplinary actions have been filed for that attorney. Usually it's in red, at the very bottom, so it's pretty easy to spot. Or if they're inactive, if they're licensed to practice. Some people fall into inactive and are no longer practicing, and it's really problematic if you look up your attorney and it says they're inactive on the State Bar website. So always be careful of that.
Yeah, we look everybody up, we hope. I noticed that you're not licensed in insurance or in securities, or you're not a CPA. Talk a little bit about, what would you think of somebody who was licensed in insurance and securities?
Well, I think there's generally an incentive to kind of double dip in a sense. I mean, if you're practicing law and then you're also handling certain other aspects, you're not going to want to refer things out. You're going to want to keep it. And it may be potentially problematic. It's because you very often with securities and other types of things, if you're acting as like a financial advisor, let's say, you make a commission, or generate fees based off of the
you can make
money
more
that you're
money.
managing.
Yeah. So
Yeah.
if I see someone that has more than one license, I basically say, go away. I don't want you, because what business are you really in?
Yeah.
It's just to be a good estate planning attorney is enough on your plate to do it well. Your practice to license practice law in California.
Mhm.
Talk a little bit about estate planning in the United States. Is there a national estate planning rules, or is that go by a state to state?
It's state to state. When I was in law school, I think it was the Uniform Probate Code or something like that, that some states have adopted, but all the rules that you learn, like in law school, on a more general basis are not the same per state. So a lot of things are different from what I learned in law school in California, because it wasn't California specific. So generally speaking, the rules that govern estate planning and probate are based on the state in which you are residing at the time you pass away.
And also where you have your property.
Yep, exactly.
So, so if somebody has property in Texas, you would probably refer somebody in Texas to handle that property if it was not in trust.
Yes.
Okay. And then you put your client's interest first before your own.
Yes.
Which is nice. And then how do you charge?
So it depends on the kind of case. I handle a lot of litigation, and that's usually hourly billing. But when we're talking about estate planning, it's usually a flat fee. So for, just in general, I think my rates are pretty reasonable for, a married couple with one property. It's usually $3,000. For a single person with one property, it's usually $2,500. And then we'll discuss, potentially adjusting the numbers if they have investment properties and things like that. There are additional costs for preparing deeds, recording documents, that kind of thing.
Okay. And what is your hourly rate?
Right now it's $400.
And do you provide a free consult time?
I do. So I do free 30-minute phone consults. That's usually enough time to see, whether it's going to be something that will work out or, whether I'd be interested in taking it on.
Okay. Because very few attorneys give free time, because that's the only thing you have usually to when you charge. If you are litigating, or do you also charge the $400 an hour?
Generally speaking, yes. I have a few cases that just have rolled over from previous, hourly rates and things, but new cases moving forward is at $400.
And do you charge for emails, phone calls, etc. during the package price time?
I do. I bill in quarter-hour increments, but I usually try to be very fair with that. I think it's a little scammy to do one email 0.25. I like to kind of roll work together. So I tend to think of myself as, would I be outraged if I were a client and got this bill?
Okay.
That's how I run my practice.
Okay. And then you're not affiliated with anyone where, you get referral fees or kickbacks on products, etc.
No.
Your only payment comes from your client.
Exactly.
And you swear on the penalty of perjury that the above is true and correct.
Yep.
Thanks for doing that. Okay, let's go to your outline, Kaylee.
Okay.
By the way, in the program, we only have charitable sponsors. We don't have for-profit sponsors. And so you're not going to get a call. You're also not going to, Kaylee does not receive any of your contact information. So if you want to do business with Kaylee, please touch base with her. And only thing that Kaylee sells is her services. And no one is going to solicit you for business or for a donation. So hopefully this program is educational. And most people believe that estate planning is all about death planning. And one of the things that we're going to learn today, it's just as important, if not more important, to have these documents while you're alive. So let's get going.
Okay.
Let's go to the first page. And there we go.
Awesome. Okay. So what is an estate plan? An estate plan refers to a collection of documents executed for the purpose of planning for your death or incapacity. So most estate plans include the following documents. So trust, assignments to trust. I know that over the course of the this seminar series, you're going to be understanding in detail what some of these things are. So I won't talk in depth about some of them. Some of them, I think there are aspects of them that you need to understand. But for example, I'm not going to go into detail about what a power of attorney is or advanced healthcare directive, because you'll be covering that, I think, next
week,
right?
Yeah.
So, but this is standard. My documents usually, or my estate plans always include these documents.
Yep. And when somebody says that they just want one of these documents, would you just give an estimate as to what the cost would be for the person?
Generally speaking, yes. I like to look at their entire plan before I say that, because I think
Okay.
that, excuse me, hold on. So in general, I think that sometimes people have a sense of what they need, and they need a little bit more than, but I like to not overdo it and not recommend that somebody redo their whole thing if they only need to make a couple of changes. So if like your advanced healthcare directive power of attorney is exactly as you want it, I don't see any need to change it, generally speaking.
Okay.
So I will usually quote a very much reduced rate based on the project. So,
Yeah.
is it multiple documents? Is it just a single document? How much work is that document going to entail? Those kinds of things. But I tend to be very fair and I quote reasonable prices.
Yeah.
So if you do want to only change one or two things, let me know and I'm happy to help with that.
Yeah. In an estate plan, one of the things is that you're giving legal authority to another individual. So, that legal authority is what a trust is about, what a will is about, what a durable power is about, what an advanced healthcare directive is about. Do people have problems finding other people as to who to name in all of these documents?
Sometimes. I've been working a lot with young families, which is kind of new for me. At my old firm, we worked primarily with elderly clients.
Old
And
farts
so
like me.
but a challenge that a lot of young people have is they usually have a child that's, I work with a lot of families that have 1 and 2 year olds.
Yeah.
Obviously, you're not going to put your child, I mean, you can, with the caveat that they have to reach the age of majority.
Yeah.
But you don't know what your life is going to look like, if you live another 40 years, you don't know who your circle of people are going to be,
Yeah.
and so a lot of times they don't have any siblings. Let's pick a family member or a friend, or parents, as the case may be. But sometimes it is a little challenging. I have clients who they don't have any siblings.
Yeah.
And they don't want to name their parents because their parents are elderly and they just don't want to put that pressure on them. So in that case, I usually recommend having a private professional named in the documents.
Yeah. When you talk about estate plan, we usually talk about legal documents, but you got to start thinking in your mind, who are you going to name? Who are you going to give this legal authority to act on your behalf? Let's go to the next slide.
Okay. So who needs an estate plan? Well, everyone, but especially families with minor children, individuals or couples who own real property in California, spouses with children from prior relationships. This is extremely important because you want to make sure that you don't have that cliche wicked stepmother situation where they take control of all the assets and the kids from the previous relationship get nothing. So you want to plan to make sure that their inheritance is locked in. Families with disabled children. So there are provisions that should be put in an estate plan to allow for providing for disabled children if they're currently utilizing certain public benefits. If they get a large distribution, those benefits could go away. So it's really important to plan around that. And then because the small estate threshold in California is $184,500. So if your collective estate is less than that amount, then you wouldn't have to pass through probate, or your estate wouldn't have to pass through probate on your passing. Anything above that, which is a house in California, a large bank account, anything like that, your estate will pass through probate if you have no documents. Yeah. So it's really, really important.
Yeah, it's especially important if you're a single individual, because if you're married, at least you have your spouse to help you and take care of some things. But if you're a single individual, you become disabled or you have a stroke, you can't get into your bank account. And if you don't have an estate plan, what does the estate plan for the county provide you? A conservatorship, right?
Yep. Exactly. It's conservatorship if you're incapacitated, and then obviously if you pass away as a single person without an estate plan, then the state just determines who your assets pass to. So it's your closest living relatives.
Yeah.
So
whether you like them or not, they're gonna...
exactly.
Let's go to the next slide.
Okay. So why do we need an estate plan? To avoid probate, to avoid conservatorship, like we just mentioned, to reduce stress for your loved ones in the future, to specify funerary arrangements, and to clearly dictate what will happen to your assets on your death. So all of these are covered in various documents. There are different documents that would help avoid certain things, or help to specify certain preferences. And so you'll probably go into like funerary arrangements and things like that in the Advanced Healthcare Directive lecture next week.
Yeah.
But just generally speaking, these are a few reasons why it's very important to have an estate plan.
Yeah, Dave, we're in the business of estate planning, but 60-70% of folks out there do not have an estate plan.
Yeah.
So and that's where the courts are just log jammed and
Yep.
they're backed up. So let's go to the next slide.
Okay. So what is probate? Probate is the process of administering a deceased person's estate to their ultimate heirs or beneficiaries.
And it's in a court, right?
It's in the court. It's court supervised, it's time consuming, and it's expensive. And so commonly clients will say, well, I have a will, I'm fine. But if you have only a will and you don't have a trust, you still will have to pass that estate through probate. A will does not avoid probate. So it's really important to make sure that you have a trust so that you have the option of avoiding probate and not having to take your estate through the court system. But so here, the heirs are obviously, if you die without a will, then whoever your closest living relatives are, things would pass to. You have more selection if you have a will where you could name beneficiaries, but you still do, there's still no way to avoid probate. You still have to pass the estate through probate if you only have a will and not a trust.
Let's go to the next slide.
Mm-hmm.
Here's the cost.
Yep. So these probate code sections set forth the fees for the personal representative and his or her attorney. So usually the same fees that could be taken by the attorney for the personal representative can also be taken as commissions for the personal representative. So you're essentially doubling the amount of fees that are taken. So on $1 million estate, it's $23,000 in attorney fees. So then the same could be taken for the personal representative. So you're looking at $46,000 in fees, just standard statutory fees.
And that's not even counting court cost. It doesn't count publications. It doesn't count extraordinary fees.
Yep. And to file a petition for probate in I'll use Orange County as an example. That's where I'm based. It's about $500. And then you've got to publish notice in the newspaper, in the general circulation where you resided at the time you passed. That's, around $600 or so, sometimes more depending on the area. So, usually before the petition is even approved, to probate the estate, you're looking at $1,500 in fees, just with all the little fees that get added up. So it's very expensive.
Can easily, for $1 million estate, can easily cost you $50,000 to $60,000.
Yes.
And it can take now almost up to 2 years to go through probate here in Orange County.
Well, right now, when you file new petitions with the court, it takes them 2 months to even assign you a hearing date. I have stuff I filed in July that I still don't even have back from the court yet with a hearing date on it. So you're looking at a couple of months, and then they set the hearing out for 3 months down the road in probates. So you're looking at 5 or 6 months before they even hear the case initially.
Yeah, we have 5 probate judges for 3 million people.
Yep.
It's just not enough. Yeah, nope. it takes time. So why would somebody want to maybe go through probate?
Well, there are some kinds of creditor protections. So usually you serve a notice to creditors on all the creditors of the known creditors of the estate. And they have a certain time frame within which they need to bring a claim, or else their claim is time barred. So there is some value to that. It's not, I mean, it's not absolute, depending on the amount, the personal representative can reject the request, and then they can file a lawsuit against the estate. So usually if the amount is 10,000 or above, there is a little bit of an incentive to do that. So it's not like rejecting it is that's it all goes away, $500,000 in credit card debts and stuff just vanishes. It doesn't. But there are some potential protections. Some people like to, I mean, I don't necessarily recommend it, but some people like to, if they expect that their kids are going to contest everything, they just go, whatever, just
Might as well get
take
in front of a judge
yeah,
early.
exactly. And so, I think that there are ways that you can try to avoid, you can customize things so that the odds of your, anybody that you expect is going to cause problems actually is able to cause those problems and win, before a court. There are protections that you can put in place in your estate plan. So I generally think, I don't see a lot of advantage to having a probate. I think that in most cases, it ends up being more time consuming.
Yeah, especially if you own real property.
Yes.
Yeah. Let's go to the next slide.
Mm-hmm. So here's a cautionary tale. I changed the names, but this is an actual client of mine. So Donald Smith executed a trust in 1991. He was unmarried at the time. His half siblings were listed as the beneficiaries. He married Sally in 2000. He never made any changes to this trust. He talked about it. He said, I want to make you the beneficiary, but he never did anything to change it. And he passed away in 2023. So now he's litigating with, or my client, Sally, is litigating with his siblings over who gets to be the beneficiary. There are potential claims that could be made as an omitted spouse. So the document was executed before the marriage, and so she should inherit something. But it's a process, and it's an unnecessary process, because if he wanted to leave her everything, he should have just changed the documents to leave her everything.
Yeah,
So,
procrastination is
yeah.
probably the number one reason why people don't update their estate plan or get their estate plan completed. Because when I pay you, Kaylee, to do my estate plan, all I get is paper. I don't get a coffee machine. I don't get a trip out of it.
Nope.
I just get these legal documents, and it's not a lot.
Yep.
And so people avoid going to attorneys.
Well, and I think generally people don't like to think about death either.
Yeah,
they think they're going to live forever, and so they want to make, they don't want to confront what will inevitably happen.
Yeah, that's one thing we all have in common. We're going to die. And and the thing of it is that we never think about that we have to prepare for death or for incapacity. And we really do, especially incapacity. Let's go to your next slide.
So here's another cautionary tale for a probate. So a husband inherited property from his mother's estate. He and his wife lived in this property for 20 years. They paid down the mortgage, with their community funds. She was able to get a community interest, but he told her he wanted her to have the house. He kept saying that to her, but he never signed any documents, never prepared anything, not even a will. So he had a child from a previous relationship, and when he died without an estate plan, she had to take out a loan to buy out the daughter, and it was pretty stressful. And in this particular case, so normally when we're talking about separate property, which here it was an inheritance, it passes 50% to the surviving spouse and 50% if there's only one child to that surviving child. If there is more than one child, then it's a third to the surviving spouse, and then equally from there. So, or like if there's two children, then it would be a third, a third, a third. But here there was only one child, so it was 50-50. But they had to buy out that other daughter, and so but in any case, it was something that could have been avoided, and it was it was very It was stressful for her. You know, she cried a lot about it because it was one of those things that they had talked about. He had said to her, you know, when you're all set, when something happens, you know, I just want you to have the house. But just telling her he wanted her to have the house was not enough. He needed to actually sign something to say,
Yeah.
this house goes to you if I
Yeah.
were to predecease.
Yeah,
So-
right now I'm serving as a trustee, and the same thing. Boyfriend lived with the woman for 20 plus years
Mhm.
and promised her and the daughters
Yeah.
lots of stuff, but never
Yep.
drafted a document. And so
Yeah.
he's now deceased, and I had the bad news delivery to the girlfriend and to her daughter and her mother that
Mhm.
they need to move.
Yeah.
And it's heartbreaking because he didn't follow through on what he wanted to have done. You got to have it in writing. You can't make oral promises over a property asset and expect anyone to believe you or to follow through on it. It's just illegal. So,
and in a lot of those cases, you know, where you have a situation just like that, Pete, often the estate ends up passing to like very like peripheral relatives, people that they never spoke with or didn't have good relationships with.
I had the
And it's really
largest,
sad.
yeah, I had the largest intestate succession of 165 individuals
What?
who never met didn't even know the individual that was had deceased. So it happens. He was the youngest of 11 children, and so he was the last one to die, and he had no estate plan. So you know, it goes went to a big ladder. Let's go to the next slide.
All right. Okay, so what assets are excluded from probate? So we have what we call non-probate transfers. So anything that has a transfer on death mechanism or a beneficiary designation. So like an IRA, brokerage accounts often do, 401ks, that kind of thing. Anything that has a like independent mechanism through which it transfers to ultimate beneficiaries, we don't include that if we're looking at, do we need to probate this person's estate? So those accounts are okay. Anything that's in a trust can avoid probate. And so if the title to the property or account or anything like that is held in the name of a trust or the trustee of a trust, then we don't include it in the estate. So if all your assets pass by beneficiary designation and you have a trust, you should be set. And then community assets usually pass to the surviving spouse. So there's something called a spousal property petition that could be filed if necessary to pass and confirm those assets, just pull them in to the surviving spouse. So those things generally are excluded from probate.
So since Don's appeared, there's probably a question. So given what you just said, I'm going to confirm it. So the question is, if I have beneficiaries on all of my assets, do I still need a trust to avoid probate?
I would generally say yes, but I don't like to answer questions blindly without actually looking at things. So I don't want to say, yes, absolutely, you're fine, don't do a trust. I would have to see for myself that, you know, everything was secured in some kind of account or something like that. But generally speaking, yes.
One of the fun parts of doing these seminars is for every lawyer that we've ever asked a question, the answer always is, it depends. And so, but what my answer to this would be, one, making sure all assets have beneficiaries. I'm surprised that all of them could. The other is, if all of the major assets are, and you're now at a dollar amount under probate, then a small estate petition could in fact be made to close out the documentation, if you will, of doing it. A trust may not be needed, but there may in fact be other things needed. Two things for you, incidentally, and I always pick on my sister. My sister was married to her husband before he deceased 40 years or something like that. For their 15th wedding anniversary, he asked her what she would like for her anniversary. And she said very nicely, to have you remove your ex-wife from our property, from our home. And he went, wait, no, I was divorced and I got the house. Yes, but you never told the county.
You never changed title.
Never changed title. And he went, Good news is the ex-wife was a very good friend and said, no problem, go ahead and change the title.
Mhm.
So that's my story. Good news was he was still alive. So
Good.
Yep.
There you go.
And I'm going to expound on Don's comment here. Take all of your assets, list it, house.
Mhm.
How do you have title? What's your cost basis?
yes,
What is your market value? And in the workbook, I believe, Don, you put kind of a chart that somebody could fill in
yeah.
and do that for themselves, because everything is based on title. How do
Yeah.
you have
Right.
title? And please don't use a beneficiary designation for all of your assets. It's great mechanism for a small amount, but because you don't know what the future holds.
Mhm.
You literally have tied yourself up if you name beneficiary designation for all of your assets.
Mhm.
What if the person dies or goes to jail or is a druggie or dies before you? It's and you have dementia. You cannot change. Trust is much more flexible. So, but again, make sure you understand how you have title to your assets. Let's go to the next slide.
Okay, so earlier we were talking about conservatorship, and a conservatorship is essentially a guardianship for an adult who cannot make his or her own medical or financial decisions. So often these are individuals with advanced stages of dementia. They've just reached the point where they don't have capacity to sign new documents, testamentary capacity. So the capacity necessary to sign new documents. You usually have to understand roughly the extent of your assets. You have to understand the natural objects of your bounty, they call them. So like your heirs, who are your heirs? And you have to be able to talk about what a will or a trust are and understand how the decisions you're making in that document are affecting your relatives, like who is going to inherit and who is not.
Well, can look, think of the husband and wife.
Mhm.
Wife, I'm going to say the husband dies, or no, husband becomes incapacitated because of a stroke.
Mhm.
He has most of their income and most of their assets are in an IRA account.
Mhm.
Can the wife talk to the broker or the bank where the IRA is held and say, hey, here's a medical diagnosis for my husband. Can you please distribute the monies to me? Can that happen?
No, I mean, usually the account holder is the only one who can access the funds in there.
So
Especially on those.
so the wife would have to go to court to establish a conservatorship for the husband.
Yep.
In order to get at the IRA account.
But if they were both listed on the checking account, she could do it.
Not on an IRA account.
No, I said checking account. I said checking.
That's correct. Yeah, if it's a joint checking, then of course.
I hate when I hear from God, you know. Yeah, so this is why both husband and wife both need their own durable power of attorney.
Yes. It's extremely important. I mean, I handle conservatorships a lot. I do them a lot. Not a lot of attorneys do. And I can run them pretty efficiently, but it's very expensive compared to other alternatives. And everything is scrutinized by the court. So now what they're doing, if somebody petitions to be appointed the conservator, there are new changes to the law that require that the proposed conservatee, so the person who would be under conservatorship, has to be appointed counsel right off the bat. And so that court-appointed counsel, if it's not the public defender, if it's private counsel, they can petition to have their fees generated as part of this. They can have them paid from the estate of the proposed conservatee. The conservator's attorney can usually petition to have their fees taken out. And some of these can get very expensive. You know, I have a case right now where I was appointed as court-appointed counsel, and I happen to know that the petitioning counsel charges about $650 an hour, and all those fees are going to get, deferred to my
It could
client's
be
estate.
$20,000 to $30,000 in the first year.
Yes.
And
yes.
what is the cost of a durable power of attorney?
Yeah, I mean, negligible. by
150,
comparison.
maybe $200.
It's, yeah, and it's part of the comprehensive estate plan, that I provide, that a lot of other attorneys provide. And it's just extremely important to get that in place.
Yeah. Let's go to the next slide.
Okay. So as I mentioned earlier, fees and conservatorship, so that the conservator can have his or her fees paid. They'll be assigned an attorney at the outset. They'll also be paid from the conservatee's estate. So all of this, all the expenses of administration are going to be deducted from that person's estate if the court orders it. And then any litigation increases all of these costs dramatically. Often what I see is families with, large quantities of siblings, so 5, 6 siblings, and they're all, I think I know what's best for dad. I think I know what's best for dad. And they all hire attorneys. And before you know it, it's like, there's 7, 8 attorneys on these cases just litigating over who gets to be the decision maker.
Yeah. And then you have the Britney Spears
Yes.
Fiasco, and
Yes.
and everybody hates the conservator.
Mhm.
It's just and the time that it takes, you want to avoid a conservatorship. Let's go to the next slide.
Mhm. So here are some options to consider in avoiding litigation. I think that if you anticipate that my kids don't really get along, I think it's going to be kind of stressful to pick one over the other to be the manager, the trustee, or the agent, as the case may be. Use private professional fiduciaries. I usually, when I have a situation like that, I recommend to clients, here's a list of 4 or 5 people that I think do a good job. I give them that information. They call up those people and they say, here's who we want to work with. And so that's an option. It helps to mitigate conflict later on.
And we'll go into detail on that.
Yeah.
There's about 1,000 professional fiduciaries here in Orange County.
Mhm.
And we'll get to that in the last session when we talk about trust and probate administration.
Mhm.
However, I'm going to ask the question now, and you can defer it if you wish, but we can ask it. So the question is, I have a question regarding co-trustees. My wife is a co-trustee on her father's trust. I'm a co-trustee on my mother's trust. I expect this arrangement will give us both immediate access to the trust funds when needed. We are considering placing our only child as co-trustee of our trust. What are the pros and cons of doing this?
Well,
this is like lighting a fire under Pete, incidentally.
Yeah.
No, it's a little different situation because you're asking with a parent and a child.
Yes.
I think that's a completely different story than naming 2 of your children as co-trustees. That's where the problems are. I serve sometimes as a co-trustee with a parent because they want to stay in control, but yet leave some of the work to the professional. So that usually is not a real big issue. But putting 2 children together or 2 friends together or 2 unknown people together.
Okay, but I'm going to raise the point. The part that bothered me was, I expect this arrangement will give us both immediate access to the trust funds when needed.
Yeah, and it does. It really helps because if you need to pay a bill, you could go right to the bank. I'm co-trustee. You can make sure that bill gets paid.
So they can act independently.
They can act independently as they should be able to.
Thank you. Thank
you. But again, it's all about trust there because people believe that financial abuse occurs outside the family. It's the caregiver, it's the rogue, this or the friend.
A lot of times it's the kids.
It's the kids. It's your own family.
Yes.
That's why it's so vast. The fastest rising crime here in Orange County is financial abuse, and it comes from the family. Doesn't come from outside individuals. So please look at your children and objectively.
Yeah.
And make sure that they can communicate with the other children.
Yep. Yep. It's extremely important.
Let's go to the next slide.
Okay. So I mentioned briefly earlier that some additional considerations for estate planning, things that you might think about when you are, will be kind of the thing that convinces you to get a trust or an estate plan. Distributions to disabled beneficiaries. So as I mentioned earlier, some of these distributions, if they receive a lump sum, somebody who's utilizing SSI or some other type of public benefit, a distribution of that amount, $20, $30, $40,000 would be detrimental. So in a case like that, and sometimes it's much more than that, consider adding a special needs trust. This doesn't mean that the beneficiary has to have special needs. It just means that, there are reasons that you might consider reserving the funds with limitations on how you can use the funds, just to make sure that it's not going to disrupt any benefits that they're currently receiving. I see this a lot with parents of children with autism or Down syndrome, something like that. Often they have a conservatorship over them, but that's another side issue. But that's one thing that is extremely important. Like I have a case right now where we're petitioning, mom needs a conservator, and mom has a disabled child. She's in her 50s. She has autism of some kind, and she's been supporting her whole life, but if she passes away and the estate is split between 3 people, the house is probably worth $800,000. So that huge chunk of money that would go to Cheryl, would be absolutely detrimental to the benefits she's currently receiving. So we may have to go into court and try to establish a trust through the conservatorship to plan for that.
Yeah, today, estate planning is all about putting a plan together that fits your family situation. It's not about taxes any longer. It's literally, tell me about your family. What problems do you have in the family? And by the way, if you don't have problems in your family, then you're absolutely abnormal, because everybody has problems in the family. The more kids you have, you reflect society. So there are issues there, and you need to disclose those issues to the attorney. That's why I want you to avoid going to those attorneys that charge $1,000 for a whole estate plan, because they're boilerplate. And that's not what you need. You want to spend time with your attorney, so you disclose to her or him, what are the family issues here? What do we have? A spendthrift? Do we have a drug problem? Do we have an alcohol problem? Do we have a multiple divorce issue? Your attorney needs to know this stuff so they can recommend who's going to be the trustee and what form of distributions are appropriate for you. And you don't find that out in the first 10 to 15 minutes. You need to disclose. Let's go to the next slide.
So here are some updates. The federal estate tax exemption is currently at $12,920,000 per person, all the way through the end of 2025. That amount is going to be reduced to $5 million plus inflation, so around $6 million or so. And so there are ways that you may want to plan for that. Right now, I think a lot of the model, the structure of people's trusts, is assuming this high estate tax exemption amount. But it is the kind of thing where, keeping this in mind, if you have a trust that was written, in the last few years or so with this exemption amount in mind, or, it's been high for the last few years, there may be some modifications that you might want to do, to the way the trust is structured, to make sure that you're not going to be taxed on the excess of that. So it's basically anything above. Right now, it would be $12,920,000. Anything above that amount would be taxed. So most families that I service are not at risk of you know, meeting this amount. So they're fine. Their entire estate would not be taxed. But as we reduce that amount, you know, assuming that this is the new standard, you know, it is something where, you know, a couple of investment properties now and a large bank account could easily put you at risk of meeting or exceeding that amount. So that is something that, you know, is something to consider and keep in mind. And I know that Prop 19 is a few years old now, but I really think, in fact, I did the same presentation a few days ago.
Prop 19, to explain, is that took the place of Prop 13 for property taxes?
Well, there's Prop 58, which is transfers to from parent to child. And basically it said that, you know, the principal residence and up to $1 million of additional properties could avoid reassessment on the death of the principal. And so what shifted with this is that there is still an exemption for transfers from parents to children, but with the caveat that it's the principal residence only, and it had to be the principal residence of the parent and become the principal residence of the child. And that exemption, you have to send it off to the assessor's office and say, I intend to live here. I'm filing for the homeowner's exemption. That has to happen within 1 year of the date of death. I have had clients who say, oh, so sorry, we got wrapped up in stuff. And they come to me a year and a half after the parent passed, and they didn't get their forms in time. So that property is going to be reassessed because they only have 1 year. And so, I mean, this generated a lot of discussion the last time that I spoke about this, because it is something that I want parents to keep in mind, that they're reminding their kids, you know, if you want to live in the family home, you have to make sure that you see an attorney. You have to make sure that you are actively taking steps toward facilitating that, because if you wait any duration of time, you're at risk of having the whole property reassessed.
And people forget that it has to be their principal residence.
Exactly.
The other part of that, though, is, especially sitting here in Laguna Beach and the houses around here, the exemption is only $1 million. If it's over that, it will still be reassessed. But they get an exemption of 1 million. So if you have that, I mean, all of this came about because of the beach houses in Malibu and the kids of people who said parent-child transaction, therefore I'm going to rent it out. That could be a $5 million house, and therefore $1 million of it will be exempted, but the rest of it will still go up.
Yeah, and you know, the other thing too is that, let's say if you have 3 children, please don't leave the house to the 3 children. You know, it's three different families who haven't lived together or spoken to one another maybe for many years can't live together. And so talk a little bit about the difference between a specific gift and a residual gift.
Before we do that, question in this one, we're talking here about a parent-child. Is the same thing for a parent-grandchild?
Yes, I believe so. I don't do a lot of transfers between parents or like grandchildren, you know. So
but I believe so too. I believe that as well.
Thank you. That was the question. Thank you.
But better Google it. Dr. Google probably will have the answer.
No, I kind of, when people come to me with specific issues, I like to not speak out of turn. So I do look things up and just verify when there's a specific question like that. But I'll admit that it hasn't crossed my desk yet.
Try not to avoid giving things to grandchildren, especially if they're under the age of 18. Talk a little bit about specific gifts and residual gifts and percentages.
Yeah, so a specific gift is like, I want my house located at such and such address to go to this person. That's a specific gift. Or just any specific thing that you want to transfer to a specific person. Whereas residual gifts are basically anything that's not designated, anything that's not named specifically, passes to what they call the residue of the estate. And then you'll usually have beneficiaries that, you know, I want either them to take, like all my children to take equally. So let's say you have 5 children, they each get 1/5 of the estate. Or you would say, oh, I want, 30% to go to this child and I want 10% to go to this child. And, some families prefer to do percentages in that way. Others are like, I don't care, just divide it evenly between my kids. I want it all to go evenly.
If you do an unequal distribution to your children,
Mhm.
you may have issues because kids or believe that the amount you leave them is the amount of love that you have for them. So sometimes it leads to litigation and problems. So make sure you discuss that with your attorney if you're going to do
Yes.
unequal. And I have a situation right now. One more quick thing, Kaylee.
Mhm.
They have 4 properties, 4 kids,
Uh-huh.
and they gave 1 property to each child.
Did they specify which property?
Yes, they did.
Okay.
And the thing of it is, at the time she did it, the properties were fairly equal in value.
Yep.
10 years later, they're not. And so 2 of the kids are just absolutely up in arms and saying, hey, mom intended us to have an equal distribution. And here, it's totally unequal. I try to get people to avoid specific gifts if at all possible.
That's generally my preference as well. I just think that it's a lot easier. Okay, we've got these 4 properties, we've got 4 kids. What do we want to do? Do we want to sell them? Do you want to take, do we want to buy out some, it's a lot easier to structure something like that than deal with the litigation as a result. It depends largely on the family though, too, because sometimes they'll just go, whatever it is, what it is, the market did what it did over the last 10 years. And so this is what mom wanted me to have. And some people will gracefully accept that. And others just want to set everything on fire. So
let's go. We got, let's see, how much time do we have left? We have approximately 20
minutes.
Okay.
Thank you. Thank you, God. I mean, God.
Except I'm going to tell you, I want the last certainly 5 or 10 minutes. I've got a couple of questions I'm holding for the end.
All righty. Give us a heads up when we get there.
Okay,
cost comparison.
Here's a cost comparison. So conservatorship obviously happens during your lifetime. It could be anywhere from 10,000 to 500,000, and it varies by complexity of the matter, whether it's litigated. I have a case that's going on 5 years now, and there's six siblings, and they don't get along. A couple of them do, but most of them are all anti one of them. And she just wants to set everything on fire. And so everything, we were going to go to trial like 4 different times, and every day she showed up and tried to delay things. And so it's like sometimes people will just drag things out unnecessarily in conservatorships. And so it's definitely, there are a lot of, reasons why that's not optimal.
You want to avoid it. You want to avoid probate as well.
Yes, exactly. And so, like I mentioned earlier, $23,000 for $1 million estate. This doesn't include any extraordinary fees that could be ordered by the court. So generally selling property, engaging in litigation, there are a few enumerated things where that's outside the scope of a traditional administration, and you can request fees over and above the amount that is the statutory amount.
Yeah. When we get to the wills and trust session, we'll better define what is a probate estate and what is a taxable estate. People get those 2 things very confused. Let's go to the next slide.
Okay. So then estate plan, generally speaking, the affordable ones are anywhere from $2,500 to $5,000. So you could have the costs on the previous slide for this one. And then
you have a Midas commercial, you can pay me now or you can pay me later.
So this is a common question I get. I already have an estate plan. Do I really need to update it? And, to laugh at what we were saying earlier, my answer to that is usually it depends. I want to see a copy of your documents. I want to hear any potential changes that you have. Have you bought and sold properties? Have you recently married or divorced? Have you, had any children? Have your
trustees changed?
Yes. Or, you know, I have cases where we've ended up with a conservatorship with somebody who carefully planned, funded her trust, did everything, because the people that she named on her healthcare directive had all passed away, every single person. So it was like there was no one there to act. So sometimes it is
have they
necessary.
moved?
Yes, yes. And you always want to make sure if you buy any property, if you move to a new location, you buy that place, you want to make sure that your estate plan is updated, because if anything ever goes wrong with title, it's really important to have that written down in the estate plan, because we can avoid probate by filing a petition to recover that into the trust if necessary. But the key is it has to be named in the document. We have to have the address in the document. So
Let's go to the next slide.
Yeah, yeah.
Oh, let's stay with that one for a moment.
Okay.
So the issue is I have existing documents. They're really nice, everything else. They're only 15 years old. If I come to you with those ancient documents and you have to change a little bit, are you going to charge me a whole fee just because you're now responsible from a litigation standpoint, a legal liability standpoint, or are you just going to change the names of the trustees?
So if the only change and no
I was
other
baiting
changes,
you, I know. Yes.
Yeah, if the only change is, well, I just want to update my trustees, and I look through and I'm satisfied that the structure of the trust is still legitimate, it's still fine, and that's the only change that you want to make, I will charge a very reduced fee.
Okay.
But I'm going to be honest with you, you know, I'm going to review everything. And if I think there are more than a couple of changes, I may recommend redoing the whole thing, but it just depends on the set of circumstances.
If I had a trust and I make changes to it, do I have to retitle everything because it's a new trust?
No.
You're replacing what was there.
Yep.
But the
Yep.
title
So you
stays the
can-
same.
Yeah, you can amend and restate your document. So it's
Right.
basically like just revising it.
Right.
But everything, name of the trust, everything stays the same. So you don't have to go through the process all over again if you did it, let's say 15 years ago.
Thank you.
Let's go to the next slide.
So when should I make an appointment with an estate planning attorney? I generally say, I have what I call the 5-year rule. So if you have documents in place, I think review them every 5 years is a good idea. I think, like I mentioned previously, on any marriages, deaths, births, divorces, those kinds of things, see an attorney. A lot of times I have spouses that they have what they call an AB trust, and they don't realize that they have to go see an attorney or at least allocate some of the assets on the death of their spouse. So they just continue using the money. They never fund the second trust. So the way an AB trust works is, and some of you may have them, it's that on the death of the first person, the trust splits into two trusts. And so you put some assets in one trust and it's irrevocable, and then the rest of the assets stay with the survivor, and that portion of the document stays changeable and amendable. So sometimes I see clients come in and they say, okay, you know, I want to update my documents, but they never funded that trust. You're creating all kinds of litigation problems later on down the road. So it's a really good idea to go see somebody and make sure there's nothing you have to do.
Once you do an estate plan for a particular individual, and they say, I would like for you to review it in every 5 years. I'm sure you will ask the question, what kind of changes do you have in your life? And then you will quote them a fee as to what those changes would cost.
That's exactly right. And even if I wasn't the one to prepare the documents initially, if, I just look at what they want changed, what's changed in their life, the quality of the document, because sometimes I'll get clients who bring in like a legal Zoom portfolio, and I almost always recommend, updating those. So it depends on, I do pride myself in being very fair with fees. So I'm not the kind of person that just, you show me a trust, I'm going to barely look at it and say, you owe me the full amount. That's just not who I am as a person. And so I think that, obviously, I'll be honest with you, if I think that redoing it is in your best interest, but if you only need to make a couple of changes, I would reduce the fee accordingly.
Let's go to your next slide.
It's just the end. So.
All right, Don, come on back. By the way, if somebody emails you, can they, with a question, will you answer them?
Yeah, of course. Of course.
Great.
Yeah, please do.
We love it. Why don't we come back?
Kaylee, you can stop sharing at
Okay.
this point. just so they can see more of us.
There we go.
Okay, so we have two interesting questions. One of them goes back to the co-trustee question we had. And I just wanted, there was a question that came in at the time, but I want to go back to it now. If a co-trustee, parent/child, can the funds be accessed if a child is sued independently? Ooh.
No.
Thank you. That was for, for two people who are lawyers, that was interesting that both of you said no. Why not?
Because the simple answer is the trustee only manages the asset.
Yeah, it's not.
They're not the
funds.
owners.
Okay.
But
get...
this is a really good reason. If they had the property in joint tenancy, you'd have a completely different answer.
Yep.
That's why
That's a good point.
Title is so important.
This is one that we get every session that we do, every series that we do. Can a stepchild, not adopted, make funeral arrangements and get death certificates? The only other living relatives are out of state and don't want to get involved in this whole process.
Yeah, they can.
They can. And it's worth mentioning, you'll mention this next week, I'm sure, but the person who has the highest priority in terms of being able to make funeral arrangements is the agent on the Advanced Healthcare Directive, even above a spouse.
Yes.
So sometimes it's the same person, but sometimes it's not. So,
but if that didn't exist,
yeah,
a stepchild is fine, not adopted.
Yeah.
Okay. Those are my two questions.
Your two most important documents in an estate plan is your Advanced Healthcare Directive, which has nothing to do with money. And two is your durable power of attorney. Because that situation that we were talking about where one spouse wants to get into another spouse's IRA account, they can't do it without having that legal authority that you get under the power of attorney. And medical, I mean, you need an advocate today. You need somebody who understands your medical situation. Here in Orange County, we have, besides Chalk, we have St. Joe. I guess it's still St. Joseph's, Mission VAO. You have Hogue, you have UCI, you have City of Hope. All of them want you to have named somebody who has legal authority to make decisions if you go into the hospital.
Well, and what is interesting too about those two documents is that, one of them survives after your death and the other one expires on your death. So the power of attorney has no effect on the death of the principal. But the Advanced Healthcare Directive, they can continue to use the authority given to them in that document, like I said, to make funeral arrangements, to arrange for burial, all of those, disposition of remains, everything. They can do all of it.
Yeah, and the trustee or the executor would have to pay for it.
Right.
So, you hope that you named individuals who get along with one another.
Yeah.
Can a grandchild get a death certificate?
Yeah.
Almost. Yeah, they've tightened up a little bit on who can get a death cert, but it's pretty much anyone. All they have to do is state that their family or they're the trustee or the executor. They don't ask for any kind of documents to verify whether or not you are.
It's interesting. You say you were listing off the hospitals in terms of Advanced Healthcare Directive. I had cataract surgery in January. And I whenever I go in for anything, I automatically walk in and hand it to them. They go, "Oh, we were going to make you sign this one," which said Gene's in charge. Right. I'm cataract surgery. This is fairly benign thing, I guess. But
anyway. And we're going to go into the Advanced Healthcare Directive next week. But it's an important document, not just from the legal end. It's also, they're going to make decisions about your body and where you live and
where you live later.
And where you live later. And by the way, funerals, they're for the living, so you may want to ask your children as to, what do you guys want You want a celebration of life? Do you want a full-on funeral? If you're faith-based, you know, do you want a church or a synagogue, or, you know, I mean, I had an individual who was Jewish, and I had talked to him beforehand, and he says, I just want you to cremate me. And boy, did I hear from the family that there wasn't going to be a wooden coffin. Well, I guess that's in the Jewish tradition. So, you know, it's incapacity, death are highly emotional issues. And the more you kind of prepare for that and the family prepares for it, the better off you're going to be.
Well, and it's really important as well to make sure that those wishes are very clearly identified. So I had a case years ago, and this will just take a second, but and basically he said he wanted these named individuals to get $10,000 if they went to his funeral funeral services at each of these 3 locations. And it was like Thailand and Mexico and Canada. But it wasn't clear to me on the document, like, do they get $10,000 for going
Each
to
time?
all 3 for each place? You know, do they all have to be there? Does it have to be a funeral service? Can they just go and call it a funeral? You know, can they go individually? Do we have to schedule services? It was not clear at all. So I had to go into court and get
I
some
had a similar
clarification,
situation
you know?
where they said that I want the family to attend my funeral, and he wanted to be buried in Arlington, and he died here in Orange County.
Mm-hmm. Yeah. So do you pay for the family to attend? Like, is it just all expenses paid? I mean, these are things that you need to be thinking about. And, you know, I mean, as a litigator, because I would say about 60% of my cases are litigation. One of the benefits of that, though, for a drafting attorney is that I'm incorporating litigation issues into my documents.
To avoid litigation.
This was a huge headache. So let's make sure that our documents are really tight on this issue. Those kinds of things, you learn how to run litigation cases and how to make your documents even more bulletproof and clearer and more articulate, you know, as you go through some of these issues and see how people do it poorly, you know?
Yeah. Litigation is not fun.
Quick question.
Sometimes it is.
For the attorney.
Quick question. If a person is stated an advanced healthcare directive moves, do you need to have a new advanced healthcare directive created just for a change of address?
No.
Please, but don't, if somebody moves and you've named them as your agent in your healthcare, get somebody else.
No, Pete, they could have moved down the street.
Okay.
They moved to Hawaii, which is a whole situation.
That is another point. Like, make sure that you are keeping updated addresses in with your, like, I have had issues. I represent fiduciaries a lot, and they don't put addresses. Sometimes the drafting attorney won't put like addresses for beneficiaries and other contact information in the documents. So sometimes they'll be like, okay, we have to try to find John Smith. And like, if you don't have an address to go off of or contact information, it's really hard. You have to hire an air finder to try to collect or get information about those people. So as a matter of just practice, I always include all the contact information, even for the beneficiaries, in the documents, because I think it's a good thing to do in making sure that the future person can contact them, or at least they have a former address that they can research.
One of the things that we did not talk about, well, I thought I'll bring up right now because we got about 5 minutes, is the gift tax. What is it? And is there any issues with the gift tax, Kaylee?
She had the exemption in.
I
did.
The
exemption.
The tax is up to 40%, but that's over and above 12,009, sorry. Which may well be reduced to 6. So we did discuss that.
Okay.
You were asleep, Pete.
No, I did hear the word $17,000 per year.
Well, that one.
And if you give more than 17,000, all it means is that you do a gift tax return. People are confused, thinking that if I give over 17,000, then I have to pay a tax. No, you don't. What is the step up in basis rule? What does that mean, Kaylee?
So generally, when you're looking at calculating capital gains, so you have a tax basis from when you purchased a property, and generally, when you pass away, that basis gets stepped up so that the amount for capital gains purposes, it's basically like if you sell the house right away, you really are paying next to no capital gains. When you have community property, you get that double step up. So on the death of the second person, it steps up again. And so, usually the question that comes up for, my cases, I'm doing like conservatorships and things like that. There's a need for money, but it's, do we hold on to the house and try to find other ways of acquiring funds? Because ultimately, if they purchased the house 30 years ago, the capital gains on that it's going to be substantial if we sell it now versus if we hold on for another 5-10 years, and do whatever we can. Sometimes I have cases where, they're in their late 90s and we're kind of running out of money, but it's like, yeah, I don't know, it's kind of a judgment
There's no
call.
choice.
Yeah.
What about making a gift of stock? I give Apple stock to my son. What would be my son's cost basis if he were to sell it?
Is he alive or dead? Are you alive or dead?
I'm alive.
Your basis.
Yeah. So
you paid $100, it's $100. If you die,
exactly,
it's current value.
So
your IRA does not step up in value, and it is taxed as ordinary income when it comes out.
Yeah.
So if you're making gifts of high valued items, you may want to consider giving through your will or trust to avoid that capital gains tax if the person you're giving it to is going to be selling that item.
Thank you very much to both of you. It's been good. I think we've got a lot of good things covered. We've answered the questions that have come in. This is week 1 of It's Your Money. Next week we will.
Your estate.
That was yesterday. I'm sorry. Let me go over here because that was yesterday. It's Your Estate. So next week, I figured it out when I started to make the comment of what? It's not planning to. Next week, we're going to do advanced healthcare directives and powers of attorney. So we will go into much more detail on those two then and carry on through.
Kaylee, thank you so much. Excellent job.
Yes.
Really enjoyed your presentation. Denise, if you're still there, thank you so much for being a sponsor.
Thanks, everybody.
All right.
Thank you.
And Don, thank you for being God as normal.
And we will see. And we'll see you next. We'll see you next week. Same time, same place. Thank you very much.
Take care.
Take care,
Bye,
folks.
everybody.